establish a village of leaders. These new technologies will enable full viewing and recording of possible sessions. Enhance room audio facilities to ensure good quality sound from the court as depicted in the top mount. Viewing screens in the gallery. These enable the court audience to have more enhanced view of the court proceedings. The Supreme Court also developed Nigerian case management NWOKEUKWU, which will enhance the transition to a paperless administration. Indeed, we are at the implementation stage. But the good news is that all courts, including trial and appeal courts, will be transmitting at the same time. This intervention will save time and eliminate unnecessary human contact that will result in unprofessional conduct from the audio-visual experiments are up and running now at the court room. This intervention will make it possible for courts to receive evidence by video from witnesses who can authentically hear in court. Would this kind of work among others? Also, the Nigerian legal email system has been developed to facilitate easier and more secure electronic communication between the people.
Hello.
My Lord, ladies and gentlemen, while we are not unmindful of challenges in the we are strong in the conviction that we are able to do this. In 2018 legal year where we celebrate be a great year for the judiciary as we endeavor to deliver justice to all. We therefore commend this legal year with renewed hope and vision. I am confident in the on behalf of my many brothers and brothers, that the Supreme Court will remain at the vanguard of the protection of democracy and rights, rule of law, and expedited reform. This reality on our individual and collective moral and spiritual foundations. On behalf of my brother justices of the Supreme Court, I extend our sincere gratitude to all our distinguished guests and well-wishers who are gathered here from far and near to witness this momentous occasion. It is now my singular honor and privilege to declare the Supreme Court of Nigeria 2017-2018 legal year open. I wish you all a fruitful and a happy new legal year. Thank you, and may God bless you all. Amen. The next address is by the Honorable Attorney General, Abubakar Malami, Esquire, SAN.
Walter Onnoghen, GCON, and my Lord, Justices of the Supreme Court, serving and retired. Your Excellencies, the Vice President of the Federal Republic of Nigeria, in the persons of Professor Yemi Osinbajo, SAN, GCON, serving, and Chief Alex Ikweme, retired. Sorry. My Lord, the President of the Court of Appeal and Justices of the Court of Appeal, serving and retired. My Lords, the Judges of the Federal High Court FCT High Court, State High Courts, and the National Industrial Court. The President of the Nigerian Bar Association and members of the executive of the NBA at national and branch levels here present. Your Excellencies, the executive governors of Sokoto, Bauchi, Ogun, and Kogi here present. My colleagues, the members of the Federal Executive Council here present. My learned brother Silk, distinguished and honorable members of the National Assembly here present, distinguished learned friends of mine, and distinguished ladies and gentlemen. I am delighted and indeed highly honored to have been invited by His Lordship, the Chief Justice of Nigeria, Honorable Justice Walter Onnoghen, GCON, to deliver a speech on this occasion to mark the commencement of the 2017-2018 legal year, as well as the swearing in of the newly appointed senior advocates of Nigeria. My lords, distinguished ladies and gentlemen, let me commence my address by giving thanks to the Almighty, by whose grace and providence we all are here to witness the commencement of another legal year. It is my prayer that we shall all witness divine favor throughout the year and end it successfully with greater accomplishments. At this point, let me further congratulate His Lordship, the Chief Justice of Nigeria, Honorable Justice Walter Onnoghen, GCON, on his well-deserved appointment as the Chief Justice of Nigeria on March 7, 2017. I have no doubt in my mind that the Supreme Court and the entire judiciary will benefit immensely from your wealth of experience and continued guidance as you discharge the onerous responsibilities of your high office. I am confident that you will continue to build on worthy legacy of your predecessors in office in steering the ship of our judiciary. It is particularly encouraging that your Lordship has already commenced a vigorous process of reforms aimed at repositioning the judiciary to play its constitutional role in a more humane and efficient way and manner. I must also commend your Lordship's circular on practice direction of 28 May 2017 on the compulsory enforcement of arbitration provisions in contracts by our courts in order to promote faster commercial dispute resolutions and foster greater confidence in our judicial system by domestic and foreign investors. This directive will no doubt help to stimulate commercial transaction in Nigeria and thereby support the vision of the present administration to promote economic development and growth. Directives, my Lord, on designation of special courts solely for the purpose of hearing and speedy determination of cases on corruption and financial crimes is equally commendable effort. The commencement of new legal year offers us an opportunity to reflect on the challenges of the first year, review the strategies we employed to confront them, celebrate our successes, appreciate our limitations, and then project into the future with a view to improving on the present indicators. This year's occasion cannot be different. As judges and lawyers, this is an opportunity, therefore, for us to rededicate ourselves to the rule of law, which is the basis of our democracy and constitutional order. Today, our country faces serious political and constitutional challenges from different sectors. In view of its role as the ultimate arbiter of disputes in our polity, there is no doubt that this court will be increasingly required in the coming days and years to interpret and adjudicate on various matters affecting the sustenance of our national values and the sanctity of our political system. I trust that in this endeavor, you shall continue to dispense justice in a fair, firm, and courageous manner in the overall national interest, as you have done over the years. A precedent, my Lord, has been laid by this Honorable Court in the case of Dokubo Asari versus the Federal Republic of Nigeria, where this court held that where national security is threatened, the individual rights of those responsible take second place. The federal government will do whatever it takes within the context of the precedent that has been set by this Honorable Court to ensure peace and security of the nation in the sustenance of our democracy. It was the revered Honorable Justice Chukwuneta Futa, JSC as he then was, who in one of his profound literary intervention succinctly captured the essence of pivotal role of the judiciary in the sustenance of the democracy in the following words: the law will have little relevance if it refuses to address the social issues of the day. Legislators make laws in abstract, but the court deals with the day-to-day problems of litigants and attempts to use the law to solve those problems in such a way as to produce justice. I quote, "The fair and firm resolution of contending social issues by our courts is critical to the continued confidence of our citizens in the efficacy of democracy and its capacity to resolve the challenges which they face on a daily basis. To achieve this, there is need for all the arms of government to remain focused on improving the judicial system to a level which benefits us all. In this context, let me assure you of my continued commitment to a policy of responsible cooperation with the judiciary during my tenure of office as the Attorney General of the Federation. I equally undertake to exert my utmost effort to ensure that all executive branch institutions always acknowledge and respect the fact that the judiciary is pivotal to the maintenance of law and order and must therefore be fully supported to discharge that mandate. In achieving our goal of a more humane and efficient judicial system, and as the judiciary resumes from its annual vacation, permit me at this stage to respectfully proffer the suggestion that it may be time for our judiciary to take a second look at the current system of its annual vacation, my Lord. While the practice of a 2 months plus annual vacation is historical and has become part of our judicial system, it will appear that several litigants and persons outside the legal system increasingly see this practice as a contributory factor to the delay of cases in our courts. In their estimation, my Lord, it amounts to practically shutting down the entire judicial arm for such a long time, every year, in addition to the other public holidays which are also applicable to judiciary. While courts have historically tried to address these concerns through the use of vacation judges, we all know that there is so much vacation judges can do. I am aware that in some other jurisdictions, the practice of staggered vacations is increasingly being employed as a strategy to balance the need for rest and the avoidance of total shutdown of judiciary for such an extended period in the interest of expeditious treatment of cases by all means possible. My lords, I propose this opinion confident of the capacity of the judicial arm to constantly renew and transform itself through a periodic review of its systems and processes. I hope my suggestions will therefore be treated as an input to that internal process and not an objection anyway. I now turn to congratulate our new senior advocates of Nigeria who are being sworn in today. I'm convinced, considering your years of toil and labor and the painstaking selection process through which you have emerged, that you are deserving of this eminent rank. I therefore charge you to remain shining lights in the practice of law within and outside Nigeria. I must, however, hasten to add that there are corresponding duties and responsibilities that go with your new rank. A senior advocate of Nigeria has a duty to exhibit the highest form of decorum, discipline, and dedication to the cause of justice and fair play. As a leader of the bar, a senior advocate is expected to bring to bear on the profession high standards of diligence and honor in the preparation and conduct of his cases. Let me hasten to remind you that your new status confers no immunity from the disciplinary processes of our profession or of the law for any act of misconduct. I, however, trust that you shall not be found wanting in meeting the high demands of your new ranks. My lords, distinguished colleagues, ladies and gentlemen, in concluding, may I thank my Lord, the Chief Justice of Nigeria, once more for the kind invitation to be part of this ceremony. I look forward, my Lord, with enthusiasm to a glorious legal year ahead and urge us all to work towards entrenchment of the rule of law in all aspects of our national life. I thank you all for your attention. Thank you, my Lord.
My Lord, the Chief Justice of Nigeria, Your Excellency, the Vice President of the Federal Republic of Nigeria, please permit me, my Lord, to stand on the protocol which you have already established for this occasion. We are once again assembled in this special session of our Apex Court to mark the official opening of the 2017 and 2018 legal year and to admit to the inner bar legal practitioners who have attained distinction in their practice of the law, either as legal practitioners, either as private legal practitioners, or in academia. On behalf of the body of senior advocates of Nigeria, I use this opportunity to congratulate each and every one of our new colleagues who have been found worthy in learning and in character by the Privileges Committee of our profession. It is a great achievement, and I congratulate you. We have listened to the speech of the Honorable Chief Justice of Nigeria, reporting the achievements of the Apex Court in the past 1 year. And I congratulate the judiciary for a job well done. Every discerning observer interested in what goes on in the judiciary will not fail to appreciate that there are clear indications of improvements in the services rendered to litigants and the nation in our various courts. For this, we thank Your Lordship, the Chief Justice of Nigeria, the Justices of the Supreme Court, the President of the Court of Appeal, the Justices of the Court of Appeal, as well as the heads of courts and the judges of our various high courts, and not left out are members of the magistracy, including the customary and the Sharia courts, who operate at a level where most of the everyday job is carried out. On occasions such as this create opportunity to speak to our country, men and women, on behalf of the majority of the voiceless people of the country on issues of concern to us all. We are witnesses today of the state of insecurity in our country. The headline news in our various television stations, private media, print media, and social media are replete with reports of kidnapping of citizens, abduction of citizens for no reason other than to demand and receive ransom for the release of victims of kidnap or abduction. For those of them who are fortunate to have survived their ordeal. Pedophiles are on the prowl. Ritual murders have greatly increased. Added to this is the emergence of highly armed groups from various parts of the country, threatening and demanding actions and things from the Nigerian state. I have no objection to anyone making his demands, but those who live in a civilized society under the rule of law must themselves do so in accordance with the rule of law. The result of these demands and these challenges and the consequences of this is that on a daily basis, groups of violent and armed citizens are attracting followerships and are beginning to wear the appearance of role models to our young children and the unfortunate members of our country who appear not to be capable of discerning the danger involved in that enterprise. Fueled by violence and total disregard for human life, they go in convoy of cars in any direction they want. They amass unearned wealth and exhibit openly the influence of such wealth. They make provocative pronouncements and encourage hate speeches which go to heat up the body politic. The Nigerian state is reminded on a daily basis that it has the duty to provide security and protect life and property of its citizens. The country, in response, deploys policemen and sometimes members of the military, in addition to the most troubled parts of the country. Yet our fellow citizens who are bent on criminalities are not relenting. They have their sponsors in high places, and in most cases, their followers in their war against the peace and security of the Nigerian nation do not even know the object of their enterprise. These groups recruit young and innocent Nigerians who they train in the use of arms for their criminal missions. When confronted by the nation's security and enforcement agencies, they quickly complain loudly of violation of the right of freedom. Those who complain about their rights of freedom ought to appreciate that they too must respect the rights and freedom of others. No one disputes the right to freedom, but what happens when these values collide? In the case of Alhaji Mojib Dokubo Asari, which was the Federal Republic of Nigeria, this honorable court considered the individual's right of citizens as against the security of the Nigerian nation and said, the pronouncement by the court below is that when national security is threatened, or there's the real likelihood of it being threatened, human rights or the individual rights of those responsible take second place. Human rights or individual rights must be suspended until the national security can be protected or well taken care of. This is not anything new. The corporate existence of Nigeria as a united, harmonious, indivisible, and indissoluble sovereign nation is certainly greater than any citizen's liberty or right. Once the security of this nation is in jeopardy, and it survives in pieces rather than in peace, the individual's liberty or right may not even exist. In concluding the lead judgment, His Lordship Ibrahim Tanko Mohammed, GSC, delivering the lead judgment, ended it thus. I entirely agree with the court below that a charge of treasonable felony is a very serious offense and is prejudicial to the national security. I believe neither the appellant nor the counsel would sit down to fold up his arms if on the seat of power to allow any citizen to put his reign into terror and utter helplessness or despondency while dancing to the music of a citizen who plots a coup d'etat against him. He will certainly fight it to the end. My Lord, I commend this court for this decisive pronouncement. It shows that I am not alone when it comes to the question of individual rights colliding with the security of this country. Citizens have the right to personal freedom, but the citizens also expect from the Nigerian state the duty to protect life and property of the citizen. The nation has to look for solutions and may go back the memory lane for some support. The world is today a global village. What happens in other countries may point to a solution. And I will give example of it. We all see and we all hear what actions and steps the government of this nation is taking to check the incidence of terrorism, kidnapping, and other types of violent crimes. From what we have seen and what we heard of these steps, one may justifiably say that as commendable as they are, these steps alone cannot be expected to be the only mode of responding to these national challenges. Government must look for additional means of responding to these societal menaces. Current government actions so far are designed to apprehend criminals after the criminal event. Government has to consider preventive measures to combat these acts of criminality in the country. What did the other countries do? It is logical to say that an extraordinary challenge requires an extraordinary response. During the Second World War, Nazi sympathizers lived as ordinary citizens in every country in Europe, including the United Kingdom. Regulation 18B made during that war was then introduced in the UK, conferring on the Home Secretary, who is the equivalent of our Minister for Internal Affairs, the power to arrest and detain without trial any person against whom the Home Secretary has satisfactory evidence that he is a spy or an enemy agent. That was the regulation which gave rise to the famous case of Liversidge and Anderson, which was heard in 1942. In the 1960s, a body of Irish people in Northern Ireland formed themselves into a group which became known as the Irish Republican Army, IRA. They seem to have declared war against the United Kingdom. They ambushed those suspected to be their enemies and killed and maimed innocent citizens. They went beyond Northern Ireland into other parts of the United Kingdom and disrupted public gatherings, including political party conferences. They set up booby traps and innocent citizens were eliminated. The British police and the army did their best, as security agencies in Nigeria are currently doing. Yet, legislation was then brought in to curtail the movement of suspected persons. Under the Prevention of Terrorism Temporary Provisions Act, 1976, any resident of Northern Nigeria, Northern Ireland, not Nigeria, any resident of Northern Ireland can be excluded and denied entry into England. And residents in England can equally be excluded from entering into Northern Ireland. A person so restricted can legitimately complain that his freedom of movement has been violated. But the United Kingdom had to make a choice. Whoever was detained or excluded from movement of sort should be entitled to complain of wrongful detention or exclusion. Such legislation may not be popular and may even be objectionable, but there is a very strong school of thought which holds the view that the freedom of citizen must go to the second place when it collides with the security of the nation and the freedom of each citizen to go about their daily lives without the fear or threat of kidnapping, abduction, or terrorist attacks. Detaining or restraining the movement of a potential terrorist may prevent him from carrying out all his dastardly plans and save or protect a potential victim. It may be worth it, therefore, for our governments and our legislature to look into that kind of mechanism or something similar to it, so that those citizens who are bent on disturbing the peace and security of our country could be denied that right to walk about in freedom once their involvement in such crimes are established to the satisfaction of the designated authority. For those bent on depriving their citizens, their fellow citizens of their liberty, a law to deny them of the opportunity of carrying out their criminal activities may not be out of place. Those who do not want others to live in peace do not have a right to live in peace in a country whose citizens they are terrorizing. It must be noted that many prosecutions for these offenses fail in Nigeria because of the apprehension of witnesses of the danger of appearing openly in court to testify, as their safety thereafter may not be guaranteed by the state. Unless and until security and peace is reasonably assured in Nigeria, development of Nigeria, no matter how well endowed, will continue to elude this nation, and poverty at much higher level and much more acute level will become entrenched. This is a situation which nobody wants. Our sister countries in Africa refer to us as Big Brother. The majority of the people of the world consider Nigeria as the giant of Africa. What then do we call ourselves? A little house mouse of Africa? Those who dare their own country and terrorize their fellow citizens to live in fear should not be heard to complain of abuse of their human rights. And that is this point I have been stressing to make. Turning to the judiciary, there is an undeniable fact that the majority of our judges work in unacceptable conditions. Court halls in many jurisdictions in the country are in an appalling state of repair and maintenance. Air-conditioned halls are an exception rather than the rule. Instead of the approach to a court of law indicating and validating the authority and dignity of the institution of law, most of approaches to our cause are rather in a miserable condition. In the eyes of a criminal or potential criminal, the appearance of such a dirty and miserable approach to court's premises sends the wrong signal. The National Judicial Council, the attorneys generals, federal and state, must face up to these problems. Just recently, the government of Rivers State built a block of court halls for the Federal High Court in Port Harcourt. I understand also that the Court of Appeal in Port Harcourt Hall in Rivers State is also being renovated by the state. I congratulate our colleague who is the governor of the state, His Excellency, the Governor of Rivers State, Nnaemeka, for coming to the assistance of the Court of Justice. In the same way, I call upon state governors, whether they are lawyers or not, to look into the poor state, to look into the state of court halls and their furniture. The courts in every state provide judicial service to all persons resident in the state, including the state government and its agencies. Court halls apart, there is the problem of supporting staff. No matter how well a judge conducts his cases. The wrong impression may be created by the wrong work ethics of the supporting staff of the court. Poor work ethics of some supporting staff may even increase the problem of the adjudicating officers if such staff fails to do or do wrongly what a simple process, such as a simple process endorsement on the file. A bailiff of a court may frustrate justice by indolence or mischief of not serving a process as at when he should do so. Research assistants or personal assistants to judges are meant to assist the judges in their work. They are expected to be knowledgeable and be sound in law. They need good working environment to enable them to assist the judges. The registrars and other staff are not left out of these challenges. The long and short of it is that if the judiciary is to make greater progress in the administration of justice, supporting staff need to be trained on a sustainable basis so that they can meet up with what is required in the evolving justice administration in this day and age. Training opportunities for supporting court staff should not be limited to Abuja alone. Working in collaboration with the bar and the bench in the judiciary in the various divisions can produce training programs that is meaningful and cost-effective for supporting staff in our courts. Unless we do this, all the efforts put into judicial reform may not succeed to the desired extent. To our new wigs at the bar, I welcome you. To our new colleagues at the inner bar, I welcome you especially to the inner bar. It is an honor well deserved, but the honor is not without responsibilities. In your new status as Senior Advocate of Nigeria, in addition to your duty of strict adherence to the rules of professional ethics, you must give total loyalty to the administration of justice. So much of it you already know from your years of practice. Misleading the court in any manner, or suppressing truth in any manner, or suggesting falsehood instead of truth so as to win a case are acts of disloyalty to the profession of law and constitute sabotage to the established principle of the administration of justice. You must be, in words and actions, a loyal and a dedicated member of the Nigerian Bar Association, the only umbrella body for all practitioners of law in any capacity. Consequently, your elevation is not a license for absenting yourself from the bar activities or duties or financial obligations. Respect for the bench must be unquestionable. Even if the judge was wrong, it is not for you to say so before him. It is for situations of that nature that the bar requires your response to be in the form of, as your lordship pleases. There must be zero tolerance to disrespect to your colleagues at the inner and your colleagues at the outer bar. Do not ask a junior colleague to do for you what you cannot do for yourself because you know it is wrong or bad. As you take your new wig from today, challenge yourself to what you can do to assist the administration of justice as you swore to this morning. There are many challenges, and it is for you to contribute your quota. Once again, I congratulate you on behalf of the body of senior advocates. My Lord, I turn to you to congratulate you once more and to ask to keep the flag flying. It has started. So let everyone know we cannot be looking backward. We must now all go forward. I congratulate you and the judiciary and wish you well in the days ahead. My Lord, I thank you.
Thank you. The next speaker will be President of the Nigerian Bar Association.
Does this one work? My Lord, the Chief Justice of Nigeria, my Lord, the Justice of the Supreme Court, the President of the Court of Appeal, another Justice of the Court of Appeal. I'm tempted to go as my learned colleague, Chief Okpoku, has done, to adopt the protocols established, but I must not fail to recognize and acknowledge the presence of our distinguished senior colleague, the Vice President of the Federal Republic of Nigeria, sitting here with us this morning or this afternoon. Your Excellency, you're welcome. I'm sure you're missing your professional robes, and we look forward to having you back when you're done with your assignment. I also welcome most certainly past Vice President, Dr. Olusegun, and of course colleagues, the various governors present. Let me also recognize my brother, the Attorney General. My Lord, I must begin by thanking Almighty God for sparing our lives to witness yet another occasion of opening of a new legal year. I thank my Lord, the Chief Justice, for the privilege to speak at today's special sitting of this court to mark the beginning of the 2017-2018 legal year, and also the admission of 29 very distinguished colleagues into the inner bar. I should also congratulate our noble justices for their well-deserved vacations. Gleaning through their looks, it does appear all of them have had a very good, restful holiday and are well prepared for the year ahead. Let me also use this brief opening remarks to thank most sincerely the Chief Justice of Nigeria for personally gracing the 2017 Annual General Conference of Nigeria Bar Association, which was held in Lagos from 18th to the 24th of August. My Lord, we thank you most sincerely for being present and also delivering a speech at the opening. I should apologize for the little mix-up in your subsequent participation in one of the sessions, for which you mandated Honorable Justice Aboki JCA to represent you. I think there was a mix-up in the scheduling, but Justice Aboki did present your paper at the end of the day. We apologize for that mix-up. My Lord, distinguished colleagues, it has been the tradition that on occasion of the opening of the legal year, we take time to reflect, take stock, and chart the way forward for the coming year, not only for this court, but indeed for the legal profession and administration of justice in general. In keeping with this tradition, I crave your indulgence to, on behalf of the bar, make some statements on the state of the bar, the legal profession in general, and also the state of the nation. The 2016-2017 legal year was, in a sense, to borrow the now famous Latin phrase, our own annus horribilis, a year in which we shall certainly look back with undiluted displeasure. We began early in September with a scathing and charitable description of senior lawyers as vultures, followed later in October by the now infamous raid and detention of justice of the Superior Courts with all the ensuing controversies. Then the tardy succession into the office of the Chief Justice of Nigeria, and more lately, the rumor of an ongoing criminal investigation involving the leadership of the courts. I have no intention here of stirring or raking up any wounds. I'm sure much has been learned from those experiences, and it is to the positive side I will turn to later on in this brief remarks. But now to the new silks, and I'll just skip this part of my address in order to save time. All the exhortations and all the congratulatory remarks have been made by the Chief Justice, by the Attorney General, and by our good friend and leader, Chibuike. So it will be seen in my speech in due course. But I now quickly go to the state of the bar. My lords, distinguished colleagues, let me make some remarks on the state of the bar. The year has not been without its challenges. Much of this internally generated. Some of our branches have been made in necessary leadership tussles. Some of the dramatis personae have rebuffed all efforts from our leaders to cooperate to resolve these issues. The national body was not spared. We have faced unnecessary legal challenges in courts, including a necessary challenge to our own constitution. Leadership quest is now so intense that it leaves the impression that the quest is not about service to the profession, but about something else. This has hurting our image. I'm happy to report, nonetheless, that the trustees of our association have risen to the occasion and have continued to play a salutary role in counseling some of our colleagues to allow common sense to prevail. On my own part and on the part of the elected officials of our association, we have remained resolute and focused in delivering on our mandate. We've been working hard with honesty and dedication. Last August, we delivered what majority of lawyers believe to be the most successful conference ever in the history of the Bar Association. The conference was by all standards world-class in content. It surpassed even the IBA conferences in sophistication, content, organization, and logistics. We delivered over 12,000 tablet computers to participants, fully loaded with legal resources and conference materials, which could be downloaded from the conference website. The proceedings were beamed live on several TV channels, including CNBC Africa, DSTV, channels AIT, NTA, and so on, across Africa and the rest of the world. The reaction and feedback from lawyers, the business community, and other stakeholders have been extremely positive. The NBA brand is now much enhanced. The success of the conference was a demonstration of the huge capabilities and potentials not only of the legal profession in Nigeria, but indeed of our country in general. We've continued to push on the broader reforms of the legal profession. In January this year, I inaugurated the Legal Profession Regulation Review Committee, headed by our colleague, Mr. Anthony Digbe, SAN. The committee comprised some of the best brains we can boast of. The members were carefully selected from the academia, from amongst practitioners, supported by a team of bright young men and women. The committee has since concluded its work and submitted a detailed report, together with a new draft bill titled the Legal Profession Regulation Bill. In the last few weeks, we have circulated the report extensively and asked our stakeholders for comments and feedback. We are also engaging with other law societies across the world to discuss our proposed reforms and get their feedback and also share from their experiences. During the NBA conference in Lagos, I led an NBA delegation in a side meeting with the South African Law Society. The main focus of the discussion was the proposed legal profession regulation review in Nigeria. Early in October, I will be leading NBA delegation to a meeting in Singapore of International Conference of Legal Regulators. The ICLR is a network of legal regulators from across the world and involves law societies, bar associations, independent legal regulatory agencies, government departments and courts that undertake regulatory responsibilities in various jurisdictions. The idea is for the NBA and indeed Nigerian regulators to test our reform ideas and also to benefit from the interaction and sustained collaboration with a global community of legal regulators that will hopefully impact and enhance our regulatory environment. Later at the end of November this year, the Nigerian Bar Association will be holding a 3-day seminar in London. The main objective of the seminar is to engage the Law Society of England and Wales, the Bar Council, as well as the regulatory agencies in the United Kingdom, including the Bar Standards Board, the Solicitors Regulation Authority, and the Legal Services Board, the Apex Legal Services Regulator in the UK. The workshop, which is being organized jointly by the NBA and the UK-based British Nigeria Law Forum, will also explore areas of cross-border practice for Nigerian and UK-based law firms, in addition to exploring the possibility of extensive UK-Nigeria internship programs for young lawyers. We hope to reach an agreement to place at least 100 young Nigerian lawyers and a similar number of UK-trained lawyers in top law firms in our respective countries. The objective is to use this as a strategy for enhancing standards and quality of legal practice in Nigeria by exposing our young lawyers to legal practice in an international and better regulated and advanced legal environment. We have extended invitation to various heads of court, the body of benches, the Office of the Attorney General, and big law firms to participate in the 3-day engagement. The details will soon be out on our website and can be viewed. I'll be counting on your support and all the support of all our stakeholders in this endeavor. Let me conclude the remarks of the State of the Bar by once more appealing to our colleagues, especially those with grievances of whatever nature, to sheathe their swords and join me in the great work we're trying to accomplish for the Bar. At our last annual general meeting, after the annual general conference, the AGM approved the appointment of a Constitution Review Committee, which has been given the task of looking into all grievances arising from the adoption of the 2015 NBA Constitution. The committee is headed by my friend, Malam Yusuf Ali SAN. I urge you to cooperate fully with the committee and submit your views and recommendations. Amongst the areas the committee will be looking at include the NBA succession system. It is clear that we cannot afford to continue with the current system. We must learn from other law societies and bar associations across the world, and indeed other professional bodies here in Nigeria. Our elections have become too acrimonious and expensive, involving dangerous crisscrossing of the country by contestants. They become more akin to political party campaigns and elections than the professional bodies. The system is undermining discipline in the profession. The committee will also look at the existing branch structure and make recommendations. I urge all our members to avail themselves of the current opportunity and to let us work together to strengthen the NBA. I now turn to the state of the nation's judiciary. My lords, distinguished colleagues, permit me on behalf of the Bar to make a few remarks on the state of the nation's judiciary. Some recent pronouncements by the Chief Justice of Nigeria, Honorable Justice Walter Onnoghen, gives us hope that the preceding 2016-2017 legal year, which I had earlier described as our own annus horribilis, will give way to annus mirabilis, or in simple English, wonderful year. It is our hope that this new legal year will mark a new decisive era by which the judiciary itself takes bold and strong measures to regain the full confidence of Nigerians. As I pointed out in the past, the National Judicial Policy, which was adopted in April 2016, represents a clear admission of the damaging impact of corruption on the nation's judicial system. In the words of the policy in paragraph 6.1, and I quote, "The National Judicial Policy recognizes that the greatest and most damaging challenge to administration of justice in Nigeria is corruption. And that tackling this challenge must go beyond mere exhortations and sentiments," unquote. This statement was recently corroborated by a more empirical survey conducted by the National Bureau of Statistics in collaboration with the United Nations Office on Drugs and Crimes. The survey, which was published on August 16, 2017, came up with very disturbing findings regarding the prevalence of corruption, particularly in the nation's judiciary. Of all adult Nigerians surveyed who had direct contact with a police officer, 46.4% reported to have paid the police officer at least one bribe. In the same survey, prosecutors came second in prevalence of bribe taking, whilst judges and magistrates came a close third in the ranking with 33% and 31.5% respectively of Nigerians who came into contact with them reporting to have paid at least one bribe. The figures for prosecutors and judges and magistrates were ahead of tax and revenue officers, who polled 27.3%, and ahead of also customs, who polled 26.5%. Regardless of any reservations on the methodology or accuracy of these figures, these are nonetheless disturbing findings. Thankfully, the National Judicial Policy, which I referred to earlier, at least has provided some strategy for addressing this problem. While advocating for strong disciplinary procedures as indispensable mechanism for dealing with the problem of corruption, the policy nevertheless recognizes the limitation of such reactive response. It commits to putting in place, and I quote, a mechanism that would be preventive and ensure palpable transparency that in every facet of judicial administration, and also ensure early detection of corrupt practices or tendency for corrupt practices in the system, unquote. The policy also commits in paragraphs 6.5 and 6.6 to setting up a working study group and fact-finding committees. The working group for the study of the working of the judicial system will undertake a study of, amongst other things, modalities of access to justice, practices in the registry of each court, and efficiency of judicial services. The fact-finding committees are to provide, and I quote, a platform to afford opportunity to citizens who profess factual and credible knowledge of the nature and modalities of corruption in the judicial system to ventilate such considering widespread claims in the country by several persons that corruption is prevalent and practiced with impunity in the system of justice, unquote. My Lord, the Honorable Chief Justice, the Bar Association calls upon you to urgently implement these policy mechanisms, which have already been adopted at the highest judicial level. This, in our view, will ensure that the judiciary is in charge of its efforts to redeem itself and to rebuild confidence in the country's judiciary. My Lords, distinguished ladies and gentlemen, I would like to conclude these brief remarks with a few comments on the state of the nation. We have, in recent weeks and months, witnessed heightened tension in many parts of this country. These followed agitations of secession by a group in the southeast, whilst other groups in the north had responded with the so-called quit notices. In my address to the National Legislative Committee of the NBA at its meeting in Lokoja on the 1st of June 2017, I stated as follows, quote, the Nigeria Bar Association wishes to reaffirm its commitment to the national unity and integrity of the Nigerian state. I believe, as many of us do, that we are better together than in our smaller enclaves. We recognize, however, that the task of building a strong, viable, and effective federal system, which is the most suitable arrangement given our size and diversity, is a continuous process and involves continuous negotiation and adjustments. We accordingly urge all groups dissatisfied with the present system or federal structure to continue to advocate or agitate for reforms or improvements in a peaceful and non-violent manner. The NBA commits itself to facilitating and supporting any genuine peaceful initiative for constitutional reforms in our governance or in our federal structure, unquote. At the end of our meeting in Lokoja, the following resolution was adopted. NEC reaffirms, and I'm quoting, NEC reaffirms its commitment to national unity and integrity of the Nigerian state. as it believes that we're better together than in our various enclaves. NEC therefore urges all groups dissatisfied with the present structure or federal arrangements to continue to agitate or advocate for reforms or improvements in a peaceful and non-violent manner, end quote. My lords, this remains our position. Since the Lokoja NEC, however, or communique, it appears things have continued to deteriorate. Recently, the Nigerian military launched what it called a routine military exercise in the southeast to test its readiness to contain internal security threats. Few will doubt that the activities of the organization called IPOB have crossed the line that can be tolerated in any sovereign state. No group, no matter its grievance, should be allowed to take the law into its own hands or operate in a manner that undermines the sovereignty of the states. We condemn in very strong terms activities of IPOB insofar as they go beyond peaceful agitations. We also reiterate the right of every Nigerian to live peacefully in any part of the country without molestation. We condemn in very strong terms all groups that seek to achieve their objectives through violence, dissemination of hate speech, or instigating one group against another. Nigeria cannot afford another round of violence or killings. While the Constitution guarantees the right to freedom of speech and freedom of association, the law does not permit brigandage and open violent hostility against fellow citizens or taking up arms against the state. The NBA recognizes the duty of the government and its agencies, including the Nigerian military, to contain both external and internal threats from all quarters. We, however, urge that all such efforts must be in total compliance with the law and in accordance with due process. Our experience in the Northeast has shown that high-handed strategy, rather than contain the threats, radicalizes ordinary people who fall victims of such strategy by security agencies. The NBA is making efforts to engage all authorities concerned with the current situation in the Southeast with a view to ensuring that common sense prevails. I want to use this opportunity to urge our members to be peace ambassadors and guardians of democracy, constitutionalism, and the rule of law, rather than, as we have seen in some conflict areas, being active combatants themselves, sometimes siding blindly with warring factions. Nations are built on the basis of adherence to shared principles and ideals. These include human rights, equal protection before the law. We cannot profess to be lawyers unless and until we uphold these rights to be available to all our fellow countrymen and women, regardless of their creed, ethnic background, or religious affiliations. Let me conclude these remarks by once more thanking His Lordship, Honorable Justice Walter Samuel Onnoghen, the Chief Justice of Nigeria, for this privilege of addressing this court on this occasion. I congratulate our new selves and wish us, all of us, a peaceful and successful 2017-2018 legal year. Long live the Federal Republic of Nigeria, long live the Bar Association. I thank you, my Lord.
Thank you very much. The last address will be from CON NWOKEUKWU SAN, please.
My Lord, the Chief Justice of Nigeria, my Lords, Justice of the Supreme Court of Nigeria, His Excellency, the Vice President of the Federal Republic of Nigeria, my Lord Chief Justice, for time's sake, may I have your permission to rely on the protocol list already established by you and earlier speakers. My Lords, history was made in this country today when a few minutes ago, my Lord the Chief Justice of Nigeria administered the oath on the 39 new senior advocates of Nigeria, including me. 29 new senior advocates of Nigeria, including me. On behalf of my privileged colleagues, may I humbly say all thanks, glory, and adoration be unto God Almighty, whose special grace made this to happen. Truly for us, this is a special day He, the Lord, has made. It is marvelous in His eyes, and we are rejoicing in it. Today is a confirmation of the old saying that God's time is the best. For me as a person, it will again go down in history, and I consider it a great honor and special privilege to be invited by my Lord, the Chief Justice of Nigeria, with the support and approval of his brother Justice of the Supreme Court, to present this address and vote of thanks on behalf of the other 28 new senior advocates of Nigeria. As we thank my Lord, the Chief Justice of Nigeria, for accepting the recommendations of the distinguished members of the Legal Practitioners Privileges Committee, that my learned friend Silk and I be elevated to the very prestigious, cherished, and enviable rank of senior advocates of Nigeria, we shall also remember and thank the human agents through whom God has worked to crown our efforts in this regard with success today. Principal amongst them are our judges and justices of all the superior courts of record, before whom we appeared and argued our way to victory in the pursuit to be so decorated and so celebrated today. They, together with our colleagues at the bar, learned advocates and worthy adversaries in court, who gave us the invaluable lifting hands, without which our labor will have surely been in vain. How can we thank you, gentlemen, enough? But we simply say, God bless you. Then, colleagues, when I remember these judges, my mind quickly runs back to our court halls, our judges' chambers in our various states, and the fact that up till this moment of our station in life, as an independent nation, that these judges and justices of our superior courts of record still record our daily proceedings in all our courts in long hands, and in most jurisdictions of our courts, under very scorching heat, occasioned by what is today called climate change. In some cases, when it rains, these judges take their flight because of flooded environment and leaking roofs. I have been wondering why this change in our climate condition will not change the position of infrastructure and total conditions of service in the entire judicial system in Nigeria. The situation in some of those courts across Nigeria do not meet up with the minimum standard that obtains in even some less developed countries of the world. Do we not think that these poor conditions, if allowed to persist, may one day affect or erode the confidence of the society in the system? I hope not. There is no gainsaying the fact that better funding of the judiciary in this country will surely guarantee better justice delivery system to the entire citizenry. Lack of funds or insufficiency of funds, we now know, can no longer be an excuse for not adequately funding judiciary in Nigeria. The time, in my humble opinion, has come for the judiciary to resist this executive's annual chorus of, quote, lack of funds, unquote, wherever it concerns issues touching on the judicial arm of government. After all, it is now a matter of common knowledge, even to the deaf, that the value of one abandoned building in a banana island can adequately provide the entire infrastructure needed to place Nigerian judiciary on the same pedestal with those of other leading and developed nations of the world. Who even said there are no such other buildings in maybe plantain, mango, or even sugarcane islands in other parts of the world waiting to be abandoned soon? These submissions are, however, without prejudice to the good news as contained in the address just delivered by my Lord the Chief Justice of Nigeria. And after listening to this heartwarming address of the CJN, my heart jumped for joy, as it is now clear that there is light on the other side of the tunnel. However, it cannot be overemphasized that the three known arms of government are all subject to the rule of law. And the rule of law is said to be the foundation of every civilized society. The rule of law establishes a transparent, accessible, and equal to all. I beg your pardon, so take that again. The rule of law establishes a transparent process, accessible and equal to all. The rule of law ensures adherence to principles that both liberate and protect. In 1959, an international gathering of over 185 judges, lawyers, and law professors from 53 countries, meeting in New Delhi, India, and speaking as the International Commission of Juries, made a declaration as to the fundamental principle of the rule of law. This was the Declaration of Delhi. This Commission of Juries declared that the rule of law implies guaranteed rights and freedom. The rule of law implies an independent judiciary, and that it implies social, economic, cultural conditions conducive to human dignity. The Council of the International Bar Association therefore passed a resolution in 2009 endorsing a substantive definition of the rule of law as, quote, an independent and impartial, the presumption of innocence, the right to a fair and public trial without undue delay, a rational and proportionate approach to punishment, a strong and independent legal profession, etc. The International Bar Association, they call upon the countries to respect these fundamental principles. It also calls upon each member to speak out in support of the rule of law within their respective communities. These principles, my Lord, we pledge to support and propagate at any time as senior advocates of Nigeria. My Lord, the Chief Justice of Nigeria and your brother justices, from the foregoing, I am therefore of the opinion that the days are gone when it was fashionable or the norm to say that the legal profession, including the judiciary, is a conservative profession. Such a legal profession, still seen till today as fully conservative, I submit, will be a weak one. The judiciary particularly should now see itself as neither fully conservative nor fully digitalized. It should rather assume a middle position aimed at getting for itself what it truly or rightly deserves. This is to enable it perform optimally the functions for which it was created under the 1999 Constitution of the Federal Republic of Nigeria as a separate and an independent arm of government. History and records have shown that the other two arms of government now assume this near radical posture to get for themselves what they think they deserve. But when each gets into some form of trouble or not too pleasant a situation, they both rush to the judiciary for rescue and for safety. And once the one is rescued by the judicial arm of government, judiciary ceases to exist in that one's consciousness. This situation cannot be said to represent a country governed by the rule of law. Time to emphasize this and proper solution is now. My Lord, it is my honest opinion that there may be no better time to strengthen and solidify this institution called the judiciary than now, that the National Assembly is on the rare journey of amending our Constitution. That moment is here for it to be finally and copiously placed on permanent record and in an unambiguous language that the judicial arm of government, being an independent arm of government, should be truly independent and autonomous. That moment is here when it should be placed on permanent record that the funds of the judiciary should undoubtedly and unquestionably be a first-line charge on the consolidated revenue of the Federal Republic of Nigeria. The effect, therefore, as we all know, will be that the judiciary will now be in a position to take absolute care of itself, including taking steps and addressing those lapses, clogging the wheel of progress. The judiciary will then be in a better position to play her constitutional role of delivering justice to all manner of persons without fear or favor, affection or ill will, and will then be truly seen by the general public as the last hope of the common man. Let us now right the wrongs of the past. Thank God the judiciary is today headed by a time-tested man of honor, courage and integrity, Honorable Justice Walter Onnoghen, GCON, who with the support and encouragement of his brother Justice of the Supreme Court has what it takes to lead judiciary to that promised land. Democracy without a strong, virile, and courageous judiciary will only last for a while, and the society will be the worse for it in the end. My lords, this is our chance. My lords, in addition to the oath we took before you this morning, we further promise to live up to the expectations of all men and women who are gathered here today to witness this great occasion, and indeed, the expectations of all Nigerians. As senior advocates of Nigeria, we shall continue to be leaders at the bar and mentors to our junior colleagues who are coming behind us. We shall continue to be subject to the rule of law, speak for and defend the bench all the time. We shall, in accordance with the law, defend the cause of justice. We shall continue to show respect not only to ourselves, but to our colleagues and above all to God Almighty, who gave us both life and this revived position as senior advocates of Nigeria. My lords, we make bold to make these solemn declarations because we are mindful of the fact that we were before now selected to stand before you today. We were tested, we were examined, and were evaluated rigorously and found to be men and women fit and proper to be elevated to the tasking rank of senior advocates of Nigeria. This is a testimony to the fact that since we are called to the bar or invested as men and women fit and proper to be legal practitioners, we have kept the faith and we have passed the test for diligence, learning, expertise, morality, honor, and character. We therefore cannot afford to fail at this point. My Lord, believe me. My Lord, the Chief Justice of Nigeria, I have the mandate of my learned friends, the new states, to specially congratulate you on your well-deserved appointment and confirmation as the Chief Justice of Nigeria. And again to congratulate you on your self-delivery of your first set of senior advocates of Nigeria since becoming the CJN. My Lord, the Chief Justice of Nigeria, let me, at this juncture, make a personal confession. When your Lordship's name was in compliance with Section 231 of the 1999 Constitution of the Federal Republic of Nigeria as amended, submitted to the Senate for confirmation as Chief Justice of Nigeria, I join millions of other Nigerians in praying for you. In fact, I personally prayed and fasted for 3 days. On the third day, on the third and final day, my Lord, of this spiritual exercise, it occurred to me to amend my prayer points to then accommodate my personal problem, being the most auspicious time to do so, knowing what I have gone through with the repeated applications to be elevated to the rank of Senior Advocate of Nigeria. I then called upon God and said, "Oh God, see your son Walter, an erudite scholar, a good man, an honest man, a courageous man, eminently qualified to be Chief Justice of Nigeria. Father, see me also, another good man, eminently qualified to be a Senior Advocate of Nigeria. I have been severally hit in the past by the constant change in the rules. You are the God that searcheth the heart. Please, God, search his heart and confirm that I will be made the Senior Advocate of Nigeria this year and under his watch. If so, hear our prayers. But if not, I left it there." My Lord, the Chief Justice of Nigeria, you are today confirmed the Chief Justice of Nigeria, and I confirm the Senior Advocate of Nigeria. These establish the fact that we both have a prayer answering God. I therefore declare on behalf of my friends that your tenure and service as Chief Justice of Nigeria shall be peaceful, purposeful, and fruitful. As Chief Justice of Nigeria, you will introduce positive changes to the judiciary that will empower you to also leave positive and indelible marks on the sands of time. At the end of your tenure as Chief Justice of Nigeria, men and women of goodwill will stand up and say to the world, a great man was here. In conclusion, my Lord, with all due respect, I have been asked by my learned friends, the Silk, to urge you to use you at this point as a point of contact to reach and appreciate everybody who played one role or the other in bringing us here, including all judges and justices of all superior courts of record, honorable and distinguished members of the Legal Practitioners Privileges Committee, and all their support staff, our elder brothers, the senior SILT, our spouses, our parents, all members of our families, all the registrars and all the other officers of our courts, our clients, our friends, and our well-wishers, all the lawyers and secretaries, and all other support staff in our various chambers, all the persons we met on our way to this position, our pastors, our reverend gentlemen, our imams, our sheikhs, and all praying partners, all you ladies and gentlemen who witnessed this great occasion today, for all your support and encouragement, and above all, to God Almighty, who preserved our lives and made today a reality. We pray God Almighty to bless you and prosper you as we wish you Johnnie mercies back home. In Jesus' name.
Amen and amen.
I wish to announce to our invited guests that immediately the court rises, there will be refreshment at the judges' foyer downstairs. Thank you very much. The court will now rise.
Congratulations.
Thank you for your all the effort. Thank you. Enjoy the best.